Welcome back to the Layman's Law School, where three hillbilly lawyers with Juris Doctorates sit around and discuss the issues of the day and hopefully try to demystify the law for some of the laymen out there. And today we're going to be talking about some interesting and fun stuff and that is in the news. Alex Jones and the lawsuit that,
Never heard of him.
Never heard of her.
Well, just so you know, he's a right-wing conspiracy theorist. He's the only
is
right-wing conspiracy theorist without a deal with Fox News at the moment.
Okay. Is it InfoWars?
It was InfoWars. Yeah, okay. He got banned from was it Twitter, YouTube, Facebook, just about every media outlet out there. But before we talk about that, we have to do what we always do, and that is celebrate a good week. And if you notice, I'm wearing the same outfit as is everyone else in the room. Yeah. This is what we do on Friday. We just put on the same clothes. We don't shoot two shows at the same time. Never.
Ever.
No. And so we're not, lubricated at all with drinks. But let's celebrate. We have another Doc and Stormy here, gentlemen. Here we
Cheers.
are. To another good week.
D'Angelo,
Genuine. Where's he at? We got his drink, too. Those are our producers.
I didn't know that Genuine was going to be in today.
Yeah, Genuine said he wanted one. Yeah. So they are.
Yeah, I mean, a great day for these two guys. When,
It is.
Everyone else is off today.
Yeah.
Right.
Yeah.
Cheers.
Cheers. There you go. I mean, Joe Rogan's got Jamie. We got two 90s, R&B singers as our producers, boy. We are doing things. Okay, so for those of you that actually don't know about the Alex Jones trial, this was a defamation lawsuit that started, I think 3 years ago in Texas, and it was brought by some of the families of the murdered victims of the Sandy Hook massacre. This was, a very sad mass shooting where I think 20 children and 3 adults were actually killed by a gunman. And what Alex Jones did was basically claim that this was what's called a false flag operation. Something by the government to actually drum up fear of the of guns and basically trying to make it so that the government could justify actually coming in and taking people's guns, right? To raise people's animosity about these types of weapons. Fear-mongering, that's right. And so what he claimed was these families...
borderline like flat earther.
Yeah.
Yep.
What are you talking about?
Well, what he went around and did was basically claim that these family members were actually crisis actors. And eventually a couple of the families, after having suffered some significant damages, what we'll talk about, because this had a pretty significant effect on some of these family members.
And I think, Chace, I would not to interrupt you, but we did the Johnny Depp case, and talking about the topic, Shawn, earlier, you were discussing, this is one of those cases that it's an anomaly. We just had 2 recently, but most cases that you have defamation, there's really not damages.
Sure.
These are 2 that have huge damages in a row.
That's right.
That's the difference and why it's making headlines and that kind of thing.
Right. And in addition to the defamation cases, they threw in some additional causes of action. When we say causes of action, it's basically if you're talking about a fight, there are certain combinations you can throw. Well, in the law, there's only so many things that you can actually file a lawsuit for. Defamation's one, and in this case, intentional infliction of emotional distress. When you know that you're going to do something or say something that it's outrageous, that it's going to affect somebody in a particular way, and it actually causes them harm.
That is in law school that you have a lot of reading on and try to understanding, and I understand it well, but in real life,
and it's funny
it's 1 in a million.
There's so much emphasis on that in law school,
right?
That by the time you get out,
you think
that every case is about intentional infliction of emotional distress. When it's really more of a law school issue,
right?
This is one of the This is one of the cases in which I think will be in law school textbooks.
Absolutely.
Okay, to sort of.
Drink,
I got your drink. Oh, sorry about that.
Get it together.
Yeah.
He's trying to double fist.
Sorry, I'm just taking everybody else's drink. But this is what the fact scenario of this case is. What is going to be sort of talked about as being a clear set of facts that indicate a valid claim for intentional infliction of emotional distress.
It's a law school case study.
For sure.
Is what it is.
For sure. Because the behavior, and I want to highlight this part, is that it has to be outrageous. It has to be considered amongst everybody in the community that the behavior that he's engaged in that causes the distress is outrageous, right?
Yeah,
right.
I think the distinction is there's a lot of things that you say that are wrong. There's things that I say that are wrong, and y'all all say, everybody says, that's not the level. This has got to be, like Shawn's saying, flat earther, and it has to have a reaction.
Yeah.
So it's got to be crazy, and it's got to have some kind of bad detrimental aspect.
Right, where it affects you. And in this case, of course, Alex Jones is basically denying the existence of these actual children that were actually murdered in this case. And the effect that it had on these families was significant in that he has a very, very wide reach and had at the time a very popular show. And this was, the 2012 through 2018. And his actual followers would go out and harass these families. Yeah. These families would, contact him and ask him to, stop doing this, stop, putting this out there. And then his response was to actually put their name and address on his show.
Yep.
And they had,
I think he called one of them autistic at one point or something.
And he called them slow and all kinds of, completely outrageous behavior. One of these families moved 7 times over the course of 9 years.
That just goes to show you that, what, has to be there to be considered outrageous. Mm-hmm. If this guy wants to get on his show and just talk nonsense that this, horrible school shooting didn't happen and it was just all government action, that's one thing. It's his opinion, not even close to being right, obviously. But when you have a following that is I would say rabid, and acting, and treating people this way, showing up at their houses, and then you go even further to when these people move and exposing their address so that that your followers can act upon that. That just raises it to the level of outrageous where anybody generally would say, this guy went this far. Yeah. It's almost intentional to ruin these people's lives.
Yeah. Right. And it's one of those two that's an important distinction, Shawn, is that the followers, that's the key. Because you can go, anywhere and have somebody on a street corner yelling that the asteroid's coming to hit Earth tomorrow. That person's not, and if he tells me that it tells everybody where I live and blah blah blah, but he doesn't have a following. He can't create these things. So that's not we're talking.
It's not
going
to affect you,
right?
Right.
So, but Alex Jones had that kind of crazy following,
right? And so, if we could, D'Angelo, we put up I'll show you. Like anytime you file a lawsuit and you have a particular cause of action, that cause of action will come with what we call elements in the law. Sure. Elements are just certain enumerated things that you're going to have to prove in order to be successful. And this is something that the judge will read to the jury as they're actually going back to decide the case. And first of all, so we got defendants have to sort of publish or put out there a false statement that it has to defame the plaintiff. Okay, so first of all, one of the defenses to defamation is if it's true. Okay. He could not prove because it did happen. Sandy Hook happened. So this is a false statement that he's saying that these are crisis actors and these kids didn't die. Then it has to defame the plaintiff. It has to have some sort of detrimental effect to the reputation of the people that are depicted. In this case, it was the family members that he said they're liars and they're basically faking their grief on national television, and so that element would be pretty easy to prove in this case. And then usually there's a requirement that you actually know or should have known, basically that you have reckless disregard as to whether or not the statements you're making are actually true. And then you have to actually prove damages, except for the special situations where it's what's called negligence or defamation per se. Per se basically would be those types of things where you're saying someone has a venereal disease or has like AIDS or something like that, or the person has a particular job where that kind of statement could really affect them, that so-and-so is a fraud and they turns out to be like an investment banker or something like that, where the person has a job,
on their,
right?
Their reputation and honesty.
You're right, a doctor, and this person's actually a drug addict. If you do that, it's definitely that's going to rise to the level of damages per se. But in this case, the damages associated with it, I know y'all heard some of the things, but it's pretty clear, and I don't think they'd have to explain it too much. But you deny the existence of their children that were killed. you don't really practically. Are those damages? No.
Right.
Yeah, but practically,
Yeah.
they don't have to prove a damn thing.
Sure. This part of it is not. You can't say it cost X because I denied that you had a child that died. But if you get it in front of a jury can do whatever they want to do.
Good
Right.
night.
Good night.
Yeah. Yeah, part of the reason, why I wanted to talk about this a little bit is because, this case actually didn't require the plaintiffs at all to actually prove any of these elements. And I wanted to talk about that.
Yeah, and most of the time, these elements, especially number 4 down there, is going to be extremely difficult. This one, you can't say he should have known. You have to say, basically, he knew.
He knew or said it with reckless disregard for its truth.
Right.
Yeah.
Well,
So
and
it's much more difficult.
The main thing with these cases is the damages portion,
Absolutely.
which we just talked about. Is we get calls, I guarantee, at least once a week, if not more, involving, someone put this on Facebook,
Right.
It's affecting me, it's upsetting me type thing, or and the damages is what any attorney is looking at. Well, to have a claim that's economically feasible, is our term for us pursuing for you. You have to be able to show that, Sally just didn't say that you're a bad person on Facebook and you're upset about it. You have to be able to show that Sally said you were a bad person on Facebook, you're upset about it, and there's some type of economical damage.
Yeah, it caused your nail salon to close down because nobody would come. Yeah,
And that's what people get mad at lawyers sometimes is, and we don't do this, is we make a real effort not to, is that if there's, like you said, if there's not damages there, I can still win the case.
Sure.
But then you're paying me to win a case that you're receiving nothing from.
Yeah.
Now, if that's what you want,
right.
If you say, I want my name cleared, it's kind of the Johnny Depp thing we talked about. He didn't care about the money. He wanted his name. If you want to pay a bunch of money to get your name cleared and you're still going to be out thousands of dollars, we can do it.
Yeah.
But just know the damages portion isn't going to go your way.
You can be right, but you can also be broke.
That's right. That's
So,
right.
yeah.
And the criminal action is you can be right and you can be dead.
Yeah,
or the civil action is you can be right and you can be broke.
Right. Because, I equate it when I try to explain that to clients. What I say is, hey, look, I've got a machine, a law firm, that costs $20,000 for me to move it to your land. All right? And what we do is we dig gold out of the ground.
Right.
Now, if you've got $10,000 worth of gold,
we're going to get it
100 feet down,
right.
I can go down there and get it.
Yep.
But you are going to be down $15,000. You want to do it?
Right.
Yeah. And then they start to understand the math in that respect.
Sure.
Because, to put something like what we do into motion, we're employing multiple people to work on their case in hours, and then we're spending our own money. So it's a pretty good analogy, and it helps people sort of understand the dollars and cents. But let's go back to this trial, because one of the things I was pointing out is that we have all these elements, right? But they didn't have to prove it. Why didn't they have to prove it? Well, go ahead.
Sure. You have a discovery process. D'Angelo, if you throw that up there for us, we'll talk about it a little bit. So essentially, discovery is just the exchange of information between people. We've talked about that. And you have that in every case, criminal, civil, whatever. And what for this case, there's all kind of, like, you have interrogatories, depositions, mediations, requests for production, all these things that you have to respond to, and these things go back and forth, and there's timelines, and depending on the court, federal or state, those times are different.
Let's just briefly unpack that.
For
the layman.
Sure.
What
Interrogatory.
Is an interrogatory? What is a request for production?
I'll come back to that real quick, but I just say that all these things have certain timelines, and if you don't meet them, you can have sanctions and blah, blah, blah. In this case, I think it was intentional that Alex Jones was not responding to discovery because he was going to lose that part, so he wanted to push this thing down the road as far as he can.
That's right.
So anyway,
essentially a big middle finger to the process.
Yes,
that's
absolutely.
Right. That's
absolutely.
Right.
So go ahead.
And the judge has discretion about if you're not going to follow the law and you're not going to follow the court's rules, the judge has discretion to do certain things. But let's go back to these things, the tools that you have by way of discovery. So the exchange of information, so you can actually figure out what type of evidence is in the case in order to help you prove your side, right? And so what are some of the tools we have there?
So the first, you're going to have interrogatories. Usually, and sometimes it changes the order, but interrogatories are essentially just questions about the incident and your in your life, and,
Right.
and so
In
you have to-
writing.
in writing, and their sworn
And you're
testimony.
sending these to the other party
To answer.
and the other party is sending similar type questions to you.
And a lot of times they're very boilerplate, meaning they're the same for every case.
Sure.
Because when you get involved in a case, you really don't know exactly what the issues are. And so interrogatories, the questions are a way to narrow what the issues are.
Yeah.
And then, even if you say something wrong in an interrogatory, you can amend it. You can change it in the deposition, and we'll talk about that in a second. But it's a basic tool to kind of get things going.
Yeah, and to find out who the witnesses are,
Right.
what evidence the other side has. You know what evidence you have,
Sure.
and you have to show that to the other side.
But the depositions are really the big one. So you want to do that last when you have as much information as you can. When you have the interrogatories, you kind of already know what you want the deponent or the person you're deposing to say. And then you really don't care what they say, because we've talked about this before in the past. Whether they say yes or no, you've already got that line of questioning kind of set up. And so by using depositions, which is sworn testimony, you can use that deposition in a trial. We videotape most of ours. But it also can resolve a lot of cases. If there's one, like I said, the interrogatories, in my opinion, is to narrow the issue. Now we know the issue. I depose the person who knows the information about that issue. That can resolve the case prior to trial. You go to mediation and get it resolved.
Right.
Sean, talk about mediation. I know I'm throwing a lot of legal terms. I'm sorry.
Well, luckily, just like in criminal or civil, there's a small percentage of cases that actually go, to a jury trial. Because, especially in civil, we go through this entire discovery process, interrogatories, depositions. Both parties, for the most part, know the facts.
Yep.
By
the end of all that, you know
by
what
the
it
end
is.
of that, there's no Perry Mason.
Right.
You show up and you've got a smoking gun type thing.
Right.
Don't say that too fast.
Well, in this case, but he's saying generally. In
Yeah,
some
generally.
cases.
So when in evaluating the case, both from the plaintiff's side, the person that was injured in a case, or person that was defamed in a case, and the other side evaluating the person who did the injury or did the defaming, it's all an evaluation of what is this actually worth? What
Right.
are we willing to risk, going to trial, because it could be astronomically more. So a mediation, especially in our circuit in Augusta, Georgia, it's generally mandated for,
Right.
Cases that are in Superior Court. That puts us together with opposing counsel, with our client, with a mediator, a neutral party who typically has a lot of experience in these type
A lot
of
of times
cases.
they're retired or they're past judges.
Yeah,
that kind of
retired
thing.
or semi-retired,
Right.
people that are here to work out cases, and we get to say our side. The opposing party gets to say their side and say, "Hey, this is this is what we have an issue with." There was 6 weeks where the person didn't go to the doctor.
Right.
They must have been miraculously cured during that 6 weeks.
Right.
And we're able to talk to a neutral party. That neutral party is allowed, and it's incumbent upon them to impress upon both sides the strengths and weaknesses of the case in trying to resolve it without a trial.
Yeah.
And when, Sean, you're talking about mandatory, it is not mandatory in our circuit. This isn't arbitration. It is mediation. It's not mandatory to accept the decision.
Correct.
So it's just a way to get everybody together and say, so discovery is essentially exchanging information like we talked about.
What
But
is the evidence in the case?
In my opinion, discovery tells you what is the issue. It narrows it for both sides.
Right.
And then it's the mediator's job to go, all right, here's the issues. I think you're right on this, and I think this is where you have some danger, and do that to both sides. And one of the things that Ray Chadwick, a great mediator here in Augusta, always says is, generally a good mediation is the defense pays more than they want, and the plaintiff accepts less than they want.
Going back to the discovery,
Sure.
these are rules that not only are that apply in federal court, but it also every state court has some different rules. And some of the things we're going to talk about today actually engage some of the rules of professional conduct.
Right.
Because
Well,
in a situation where a party does not actually abide by these rules, doesn't answer the interrogatories, doesn't show up for deposition, doesn't do the request for production. Right.
Well,
what happens when a judge hears about this? How's that occur?
Well, let me. When we're talking about how our practices work, we generally know and have dealt with the defense attorneys on the other side. We're plaintiff attorneys,
sure,
and we have a good working relationship. If Jace Ingram's out there and he tells me something, I don't look it up. I trust Jace, and we work together and we get things done. You generally expect, whether defense or plaintiff, that the other side's telling you the truth because you are a officer of the court. And by law, I have to tell the truth to the other side.
Sure.
What happened in this case is jacklegs, jackleg attorneys did not act professional.
100%.
And by doing that, they lost the case that had to be proven, and it went to straight damages. They didn't have to prove everything because the sanctions were, you didn't follow the rules of discovery. You've lost that. We have a directed verdict for that. The judge made that decision and said, you are guilty of the charges, essentially. And so then it became all about damages, and that was the entirety of the case. And punitives, I believe. Is that correct?
Yeah. That was it. It's just about damages. Yeah, so one of the options, is typically what happens is if you don't engage properly in discovery, the side that's claiming you haven't engaged in discovery properly will file what's called a motion to compel. That's when it gets before the judge. The judge then can issue an order. They can issue sanctions. An order is basically a statement by the judge about what has to happen and by when. Right, and that's usually the way it happens.
Right.
And what happened here was a default judgment, and that is the most harsh thing that the judge can do. But this person, Alex Jones, given their lawyers the benefit of the doubt, this was their this was his seventh law firm that had handled this case. There's a reason why these people were making millions
because 6 others refused to do what he's asking them to do.
Exactly. So this guy's a multimillionaire, right? They're raking in $125 million a year, right? And so he's got funds to pay a defense firm whatever they want. 6 of them said, "I'd rather not have your millions than deal with you." And so there's something to do with that. But like Reid says, there are some things that occurred here that are beyond the pale.
Yeah.
He might have gone through 6 other lawyers to find one that would actually listen to what he said. So
it is almost impossible to get sanctions. Like the judge, it's the judge's discretion, and the judge is an attorney too, and we're humans. We make mistakes, and the judge is usually going to say, "Listen, you screwed up, but get it right, and let's move on." To have a directed verdict is, and have it stand. The judge can say, "Okay, well, we can open this back up. We can start it over." You have to cross some serious lines,
especially in a case of this nature.
Right.
We're not talking about a
car wreck.
We have directed verdicts, on occasion, especially people that are uninsured. Don't have any attorney that's backing them up. Example: Reid runs into the back of me, causes damage to my car. Reid doesn't have any insurance. And we were to sue Reid.
And I don't know what I'm doing.
We serve Reid with a copy of the lawsuit. He's supposed to show up to court this day. He doesn't show up to court. The judge rules in favor of Shawn.
Right.
And the only thing that has to be determined after that is damages.
Right.
And if I say, well, Judge, Reid didn't show up, and here's my bill from the collision shop. It costs $1,500. The judge says, you're awarded $1,500.
Right.
That's how it is. And a case like this with millions of dollars on the line for a default judgment to occur is crazy.
Yeah, that's what we're going to talk about here because, like you said earlier, you're like Perry Mason. You were talking about having a Perry Mason moment. Not often does it happen, especially it does not happen often in a civil case or on national television. But it happened in this case. We've got some clips here, and I'll just sort of. I'll just start with this. So after this particular cross-examination, we had some tweets that came out. This is from former prosecutor Michael Etter. He said, after this cross-examination, he said, in over 25 years as a trial lawyer, I have never seen a witness do more harm to himself on the stand than Alex Jones. This includes a case where I was the prosecutor and I got a defendant to admit that he was guilty of the crime charged in the indictment on the stand. It was so bad that former prosecutor Ken White said it was like an action movie, but where it's not enough for the bad guy to get shot at the end, but he also has to be decapitated, exploded, and impaled at the same time. And so
It was cringeworthy.
it was cringeworthy. Like for lawyers that are watching this, like we're relishing what's happening for the plaintiff's attorney, but at the same time we're like, I have been where that defense attorney, where the person is just getting up there and just really destroying themselves on the stand. But let's go ahead and play the first clip, and I'll talk about what's happening here.
Mr. Jones, I'd like to show you what's been marked as plaintiff's exhibit 130. You've got it upside down. That's text messages between you and Paul Watson, isn't it?
Yes.
And they mention Sandy Hook, don't they?
Yes.
Plaintiffs move 130 into evidence.
So what he's doing there is, okay, you heard him go up there, he approached the witness, hand him a document. That's something called, he's laying foundation there. You have to show him the document, give it to a person that has personal knowledge about it, show him and ask him, what are those?
Yeah.
To identify it.
True and
and
accurate.
authenticate it. And as soon as he authenticates it, he says, I move it into evidence, right? It's a nuts and bolts type thing in the law. It's a function that we have to do.
It's not on the movies because it's boring.
No, it's boring as all get out. Exactly. But it's absolutely necessary. And then he kind of starts to lower the bomb on him here in the next little clip. But he's already got it into evidence, so now he can ask him questions about it. Now the jury's going to get to see it. The other side's given an opportunity to object. They couldn't object under the circumstances.
Alex has gotten his cough back.
He certainly has. He cannot, have a conversation like a normal human. No.
You didn't give this text message to me. You don't know where this came from. Do you know where I got this?
No.
12 days ago. Your attorneys messed up and sent me an entire digital copy of your entire cell phone with every text message you've sent for the past 2 years, and when informed, did not take any steps to identify it as privileged or protect it in any way. And as of 2 days ago, it fell free and clear into my possession. And that is how I know you lied to me when you said you didn't have text messages about Sandy Hook. Did you know that?
I told you the truth. This is your Perry Mason moment. I gave them my phone, and then...
Mr. Jones, you need to answer the question.
No,
Did you know this happened?
All right. So, just a little backstory. He was asked to produce these things. Well, his lawyers actually turned over a link to a Dropbox that also had links and access basically to the entire defense file. And when the plaintiff's attorney tried to download it, it actually clogged his servers, and he had to download it on another server because there was so much information on it. And it basically included not only all their entire case file, work product, all that, but it also included his download of his phone for 2 years. And the information contained on it is now being subpoenaed by the January 6th committee because of some of the conversations that are in there. And it was important the way you heard the plaintiff's lawyer actually say, I informed him of this.
Because you have to.
You have to. It's under the rules of professional conduct, both Georgia, South Carolina, and Texas. But in Texas, there is a specific rule. And I don't know if you heard him say, I informed him in 10 days ago, and then it fell free and clear into my possession. If you don't assert those privileges, okay, in 10 days in Texas, then you've waived it.
Right.
And so there was a separate hearing that's quite interesting to watch, and it's separate from what you're seeing here. But this is a clear case of malpractice.
Yeah.
A clear case of malpractice.
I think yes, I agree. And I also think it's just these lawyers give lawyers a bad name. Let's just put it that way. They're just, they're essentially criminals.
I've always said in my life to never, judge a person until you've walked in their shoes.
Right.
And this Alex Jones guy has been through 6 law firms, and not the Hawk Law Group, 7 attorneys, 15 paralegals, law firms, like big law
Nationals,
firms.
yeah.
And
how dare you?
he's on the 7th one.
Yeah.
And to me, the way that counsel for Alex Jones just sits there, says to me, I am so over this.
Yeah.
I'm ready to get this out. The,
Yeah.
the check has been cashed,
Yeah.
and we're just, our hourly rate is going down at this point. So is it malpractice? Absolutely. Are these guys, probably the the 7th, and there will be an 8th law firm. Absolutely.
Yeah.
But it's just
They're scumbag lawyers.
It's troubling.
They're scumbag lawyers.
Oh yeah.
Well, in this case, basically what happened was that an underling or a secretary actually sent the link and not the actual attorney.
But
He tried to lay off some blame, but he has a
is-
duty to reasonably.
The problem is the attorney should have sent that. That's part of what is asked in discovery.
Sure, no.
So the not only is Alex Jones lying, the lawyer's lying.
Sure, yeah, and
You
that's
can't do that.
right, and that's what comes out in the actual hearing between. Because what happened after this is the defense attorney actually moved for a mistrial based on this interaction here, and he basically tried to throw the plaintiff's lawyer under the bus. What you saw there was a plaintiff's lawyer throwing the defense attorney under the bus. That doesn't really happen in a lot of cases.
Sure.
Okay, we don't work
together.
Exactly. A lot when we say work together, it's like we are cordial. We compete, but it's like a sports thing. You compete
the
hard on
rules.
the field.
Right.
Okay, but as soon as it's over, you bump fists and everything. You don't try and rub it in when they make a mistake, unless in situations like this where the conduct is egregious. And the plaintiff's lawyer did everything he was supposed to, told him about it, okay? Yep. And what the defense attorney was supposed to do was assert privilege over those items which they thought they had privilege over, right? Mm-hmm. And in the hearing, when the plaintiff's lawyer or the defense lawyer actually gets up there, he basically says that, when we sent him this link, it was like he got a key to a door, and then he noticed in that room there were other doors. He's like, I'm interested in these other doors. Right. And then I told him, he emailed him, he said, hey, disregard that link, I will supplement the discovery. He never supplemented the discovery. He never went through the information that he actually did send and say what was privileged as the rule requires, right? And then when he told the judge, he's like, we need to go through this and determine, and she's like, look, you were supposed to, if you had to turn this over a year and a half ago when you were supposed to, we would have had time to actually go through and decide what was privileged and what was not. You abused that. Yep. You didn't follow the rule. It's in my discretion to let this in. I'm letting it in. Yep. It's not going to happen. And so it's going to be a cautionary tale for not only defendants, but also defendants' attorneys when it comes to actually like e-discovery has become a huge thing because you have attorneys that don't necessarily understand technology, and you have certain ones that do. And if you can exploit it, like in this case, he understood that link led to other links, and he went down that path. But he did what he was supposed to do. Right. And once you take advantage of the rules in the way you're supposed to, and you treat the law with respect, and you do what you're supposed to, the law will look favorably on you. And if you abuse it, you will get a default judgment against you.
When you get in a situation like this, there's no way that attorney reviewed that link
and what it did
and what was contained in that link prior to it being disseminated to opposing counsel.
Sure.
Mm-hmm.
So that alone right there is malpractice.
Mm-hmm.
Right? You're allowing an unauthorized person to practice law, basically.
Mm-hmm.
And listen, you've made mistakes. Chase, you've made mistakes. I've made 1,000. And the defense counsel
very
has
rare
to very
that I
rare
make
for you,
one,
Shawn,
but I have on occasion.
But defense counsels make mistakes, and they may send something this work product, and I'll shoot it back because you have a mutual respect and a mutual trust. And if something happens, you want to protect them, and they want to protect you, not to harm any. You're not doing it to. You want to represent your client in the best way possible, but you don't want to be shisty and all that stuff. And 99% of interactions in the law happen that way, and if a mistake is made, you correct it with the other side, and everybody goes on. Mm-hmm. The reason that this plaintiff attorney didn't allow that is because these guys have been so terrible.
Yep.
So terrible. Yeah. Sure. So, I don't blame the plaintiff at all. I would have done the same thing.
Yeah.
But generally, and
that's
the way that's not how it works.
Mm-hmm. That's because we don't run into those kinds of lawyers.
That's
typically.
True. Very true.
So he goes on to sort of make some more mistakes here, but it also sort of it'll allow us to talk about some of the other requirements for a defendant when he's actually complying with discovery.
Lawyers, they were supposed to find this. That's what testimony is.
No, I searched it as well. I don't know who's supposed to take it from. I mean, I turned the phone over and said, take the stuff off.
Can I have you look in the very bottom below the very bottom left corner? Is that your phone number?
Yes. So you did get my text messages. And it said you didn't. Nice trick.
Yes, Mr. Jones. Oh. Indeed.
So he's saying that he searched, and his attorneys did as well, but they didn't find it in 3 years.
No, I didn't know this happened. But I mean, I told you I gave him the phone over.
But just
and
answer the question.
You said in your deposition, you searched your phone. You said you pulled down the text, did the search function for Sandy Hook.
And I had several different phones with this number, but I did, yeah. Well, of course, I mean, that's why you got it.
Well, I put that up there just to highlight what are the responsibilities of a defendant in that situation and an attorney, and it requires them to do a reasonable search. It's pretty clear from what unfolded there that he'd never done any of the search, or maybe he had, and like Shawn said, decided it'd be better to take the hit right without them ever getting it. Yep. And it didn't.
It reminds me of a premise liability situation. But when you send a spoliation letter out, right? That spoliation essentially says you cannot destroy this evidence. You can't destroy videotapes if something happened in the store. Blah blah blah.
Yeah.
A lot of times when things are favorable, you get the video right away.
Oh.
For them,
that.
I mean.
Yeah,
and when
yeah.
things are not favorable, it disappears.
Oh.
We don't get to see it.
We record over it in
Now,
2 weeks.
Then the judge says, yeah, you can say it still says what it says, because by law, if they don't preserve it, and you say, I present that it shows this, then it does. But that's still better for the other side than actually me having the tape showing what happened.
Right.
Oh, yeah.
And so they do it intentionally. And they take the hit on the legal side.
Right.
And this one, I think, like Shawn said, they were trying to take the hit on the legal side, and they got hit with both.
Yeah.
they got hit with both.
Yeah. Well, in that case, the good news is they got a pretty good verdict. It was I think $4 million in compensatory damages, and I think somewhere around 45
50 total
in punitive, somewhere around there. Yeah. But unfortunately, a lot of states have a lot of unique laws because the defense bar has a strong lobby, and they limit punitive damages. Punitive damages are those damages there to punish the person from doing it again. The compensatory damages, that are supposed to basically just pay for the harm done, and so that will go to the actual plaintiffs in this case. That 45, though, I do believe there's a significant
there's a big cap
on it. Yeah, so I think it's something to the effect of $750,000. Or a multiplier. I think it's 2 or 3 of whatever the compensatory is. So like the max, I think it's somewhere around 15 or something like that.
So different states do it differently, but most states have some type of cap or system where that you read it in the paper, you go, well, this person didn't deserve it. Well, that person's not getting the money. They're just not. The punitive damages generally don't go to the plaintiff.
There are some advantages in that you can do it per occurrence in some states as well. So if there are multiple occurrences of the same act, and you can't really differentiate which one's caused the harm, you can actually
was here.
A lot. He was actually at one portion of the trial while people were testifying in this trial. He was not there, and he was actually doing an InfoWars show talking about the trial. So that didn't go over well. I would say this is it's interesting the fact that there's so much malpractice going on the defense side that Alex Jones has declared that he's bankrupt. The court during the trial looked at the finances and said, you are not allowed to testify that you are bankrupt.
Right.
Okay, because that is perjury. You perjured yourself twice. He got admonished by the judge. It was great. You perjured yourself twice. You are not allowed to say you complied with discovery because you didn't. If you say that again,
Do we criminal charges?
Yeah, you have the right to plead the Fifth Amendment.
I'm just going to say that when I watched that clip, I really liked the way that judge talked to him.
I did too.
There's more good stuff. So I would advise you, you can just Google, Alex Jones cross-examination, and it's a good, 30 minutes of entertaining TV, especially when you watch him interact with the judge.
Right.
He calls her a dwarf demon goblin on his show at one point. Wow. I can't imagine that went over very well.
Yeah, it's not. It's, especially when you're in any kind of trial.
No.
Insulting the judge as it's going on, not a great look. Not a great look.
Essentially, we've just given you the rabbit hole.
Yeah,
go ahead.
Right.
Yeah, go on down it. Well, thank y'all very much.
Well, we got one more thing, Chace.
Oh God,
you always forget.
I wish I cut it off.
This
week in politics with Reid.
We got to cut to Reid for the current events. This one is just, it's a politician that's just trying to get elected.
Right.
And it's just something that, it's one of his ads, and I thought it was just interesting. It's
this is a male.
This is a male, yes.
Okay.
This is
No twerking.
A twerker in a
Twerking.
bikini?
It's nothing crazy, but I thought it was interesting. I just want to hear y'all's opinion on
From
it.
a marketing standpoint, I still think in my mind, vote Senator Mack.
Yeah. I mean,
I don't know why, but I remember it.
Yeah. Okay.
All right, guys.
Thoughts?
Good ad, bad ad.
Obviously, he is very, very close with Chace Hawk because he's got one of Chase's knives.
Well,
And obviously, he's got a lot of experience in what is
bananas.
the game that is
Fruit Ninja?
played?
Fruit Ninja.
Where they're-
Fruit
yeah,
Ninja.
Fruit Ninja.
Fruit Ninja.
yeah.
He's an expert.
Well, Sean, I'm going to go ahead and tell you. Look, I don't use German knives. All right. All right. He's using German knives, so do not condone or suggest that in any way. So you're wrong on that point. But what's disturbing to me is that, we're paying politicians to make decisions for us. And this guy, an adult,
right.
decided that this was a good decision to put this out as a thing to demonstrate his decision-making abilities. I mean, I'm all for, having fun. That's what we're doing here. We're kind of
Right.
goofing off a little bit or whatever. But when you're vying for a job like that.
Let's get it back to being a little bit more professional.
Yeah.
please.
How are we going to educate our kids? I don't want to, have you doing anime videos
Right,
if you
right,
don't mind. For the
right.
love of Pete.
Super Saiyan.
Oh, is that what he was saying? He was
I don't
trying.
know.
Is that what's
That's not-
okay,
I'm just
God.
throwing it out. It's one of the
Yeah.
terms I know.
Well, God bless him. I hope he's happy.
I can tell you I'm voting for Senator Mack and not that guy.
All right, well, that'll do it for us this time. Please join us next time when we talk about Reid's favorite subject, premise liability.
Man, can't wait.
All right.